Okay, good afternoon. This is the 2024 forecast for political law for the bar exam. I hope makatulong sa mga mag-exam bukas. Let's start. First, no problem. Binibining Sheena filed her certificate of candidacy as an independent senatorial candidate in the May 2019 elections, identifying herself as a lawyer and a teacher. On October 22, 2018, the COMELEC Law Department, acting motu proprio, petitioned to declare Sheena a nuisance candidate. The petition asserted that Sheena lacked a bona fide intent to run for public office and financial capacity to sustain a nationwide campaign. Yeah, Sheena refuted these claims, highlighting her government platforms on education, agriculture, health, and housing, as well as her financial capacity, demonstrated through a paid website campaign, social media advertisements, and endorsements through various groups. Despite her arguments, the Comelec First Division declared Sheena a nuisance candidate. The decision was based on the failure to establish sufficient financial resources to mount a nationwide campaign. Sheena's motion for reconsideration was denied by the Comelec en banc, which reiterated that the financial demands of a national election campaign necessitates a strong political machinery and significant financial backing. Aggrieved, Sheena filed a petition for certiorari, arguing that the Comelec committed a grave abuse of discretion, declaring her a nuisance candidate. She challenged the constitutionality of Section 69 of the Omnibus Election Code on the ground that the provision's language, particularly the phrase by other circumstances or acts, which clearly demonstrate that the candidate has no bona fide intention to run for office, was unconstitutionally vague. Rule on the claim of binibining Sheena. The claim of binibining Sheena should not be given due course because while Section 69 of the Omnibus Election Code is couched in imprecise language, it is not vague. Jurisprudence dictates that the doctrine of void for vagueness does not apply to as against legislations that are merely couched in imprecise language, but which nonetheless specify a standard through though defectively phrased, or those that are apparently ambiguous, yet fairly applicable to certain types of activities. The first may be saved by proper construction, while no challenge may be mounted as against the second whenever directed against such activities. With more reason, the doctrine cannot be invoked where the assailed statute is clear and free from ambiguity, as in this case. Based on the case of Diablan versus Comelec, a 2022 case. Item number 2. In the case concerning the disallowance of extraordinary and miscellaneous expenses, or MF for short, in the LGU's budget from 2004-2009, the petitioners invoked their right to a speedy disposition of the case, arguing that the proceedings before the Commission on Audit, Regional Office, and Commission on Audit proper took an unreasonable long time to resolve. Specifically, the case took more than 1 year and 4 months to reach a decision at the regional level, and an additional 3 years and 7 months for the COA proper to resolve the appeal. The COA proper contended that the time taken to resolve the case did not exceed reasonable limits and that the delay was not vexatious, capricious, or oppressive. They maintained that no prejudice was suffered by the petitioners due to the delay. Question: is there violation of the petitioner's right to a speedy disposition of cases? Answer: no, there is no violation of the right to speedy disposition of cases because there was no inordinate delay. Jurisprudence states that the determination of whether the delay was inordinate is not through mere mathematical reckoning, but through the examination of the facts and circumstances surrounding the case. Courts should appraise a reasonable period from the point of view of how much time a competent and independent public officer would need in relation to the complexity of a given case. Now, if there's been a delay, the prosecution must be able to satisfactorily explain the reason for such delay and that no prejudice was suffered by the accused as a result. Based on the 2022 case of Abelia versus Coa proper. Next item. In 2006, Moses Lester, a school teacher, was convicted by the Regional Trial Court of 5 counts of acts of lasciviousness against 2 11-year-old female students. Lester filed a motion for reconsideration, during which time the presiding judge was promoted and a new judge took over the case. On 2008, the new judge issued joint orders acquitting Lester, which the private complainants contested through a special civil action for certiorari filed with the Court of Appeals, arguing that the acquittal lacked a clear factual and legal basis. Lester opposed the petition, claiming that a review of his acquittal would violate his constitutional right against double jeopardy. However, the Court of Appeals argued that the RTC had committed grave abuse of discretion by failing to clearly express the facts and law supporting the acquittal. This grave abuse of discretion, the CA determined, rendered the acquittal void, allowing a review of the case without the protection of double jeopardy attaching. Question: did the CA violate Lester's right against double jeopardy? Answer: no. The CA did not violate Lester's right against double jeopardy because the ruling of the RTC was rendered as a void judgment. The rule on double jeopardy will not apply when there has been a grave abuse of discretion under exceptional circumstances that rendered the trial court without jurisdiction. The RTC committed grave abuse of discretion, rendering the joint orders of acquittal void. Jurisprudence states that a void judgment of acquittal cannot be the source of legal rights and has no binding effect. In contemplation of law, it is non-existent, as if no judgment had been rendered at all. Based on the 2022 case of Austria versus AAA. Next question. In 2009, the National Power Corporation Board of Directors ratified a resolution granting performance incentive benefits to its officials and employees, which was later implemented through a circular issued by the National Power Corporation President and CEO Ian Arceta. However, the Commission on Audit subsequently disallowed this grant, citing the lack of required presidential approval and extravagant nature of the incentive, especially in the light of NPC's significant financial losses. When appealing the disallowance, the NPC petitioners argued that the performance incentive benefits had implicit presidential approval, as the NPC board included several cabinet secretaries who were alter egos of the president. They posited that the doctrine of qualified political agency should extend to the board's actions, implying that the decisions made by the board carried the weight of the president's authority. Question: is the contention of the NPC petitioners or the National Power Corporation petitioners correct? The answer is no. The contention of the petitioners is not correct because their actions within the board do not necessarily reflect the president's direct authority. The doctrine of qualified political agency is explained or elucidated in previous jurisprudence cannot be automatically extended to the acts of a board of directors, even if some of the members are cabinet secretaries appointed by the president. These secretaries sit on the board ex officio by virtue of their position and not through a direct presidential appointment to the board. Based on the case of NPC Board of Directors versus COA 2021. Next question. Okay. In 2007, Maloy was appointed to the Board of Directors of Binicorp, a government-sequestered entity supervised by the PCGG. Despite the expiration of her term in June 2010, Maloy continued serving in various capacities, including as Vice President until 2010. Before her term ended, Maloy and other board members passed a resolution granting separation benefits to Binicorp officers, from which she received a total of 544,178 pesos and change. This led to a complaint filed by Binicorp's General Manager Colette alleging that Maloy's receipt of the benefits caused undue injury to the government, violating Section 3E of RA 3019. Colette argued that Maloy's actions were in breach of Memorandum Circular No. 40, Series of 1993, which limits the compensation of PCGG-nominated directors in sequestered corporation. Maloy defended herself by claiming that the ombudsman had jurisdiction over her, as she was Maloy defended herself by claiming that the ombudsman had no jurisdiction over her, as she was not a public officer, and Binicorp remained a private entity despite government supervision. However, the ombudsman ruled that Maloy was indeed a public officer, as the state owned almost all of Binicorp's subscribed shares, making it a government-owned or controlled corporation, a GOCC. Despite this, the ombudsman dismissed the complaint, citing a lack of probable cause. It determined that Maloy's receipt of the benefits was not related to any judicial, administrative, or official functions, an essential element required to establish a violation of Section 3E of RA number 3019. This is a contention of Maloy that the ombudsman has no jurisdiction over her, correct? The answer is yes. Yes, the contention of Maloy that the ombudsman has no jurisdiction over her is correct because she was not a public officer. Section 2B of RA number 3019 states that the term public officer includes elective and appointive officials and employees, permanent or temporary, whether in the classified or unclassified or exempt service, receiving compensation, even nominal, from the government. Based on the case of Kyoge versus Estacio, 2021. Next question. Bini Janet, convicted of plunder for her involvement of the misuse of Senator Lingling's Priority Development Assistance Fund, or PDAF, is currently detained at the Correctional Institution for Women. Pending her appeal, Bini Janet seeks provisional release on humanitarian grounds, citing the risk of contracting COVID-19 due to her underlying health condition, diabetes. Bini Janet invokes that the fundamental right to bail, which is rooted in the presumption of innocence. This right, as articulated in legal doctrine, serves as a balancing mechanism between the accused's provisional liberty and society's interest in ensuring the accused's presence at the trial. Bini Janet argues that her provisional release is justified under this principle, referencing relevant case law and the Office of the Court Administrator's Circular Number 91-2020, which emphasizes the enforcement of an accused right to bail and speedy trial. She also cited the Nelson Mandela rules, advocating for the release of persons deprived of liberty during public health emergency. First question. Should Bini Janet be allowed to post bail pending the appeal of her conviction of a capital offense? The answer is no. Bini Janet should not be allowed to post bail pending the appeal for her conviction of a capital offense because the rules of court bars any application for bail when the penalty imposed on the accused exceeds 6 years. Question number 2. Should Bini Janet be provisionally released on humanitarian grounds due to the risk of contracting COVID? The answer is no. Bini Janet should not be provisionally released on humanitarian grounds due to the risk of contracting COVID because the allegation is a question of fact which is not within the province of the court to determine. Neither can the court take judicial notice of her medical condition. However, even assuming that she is indeed suffering from diabetes, that in itself is not sufficient to grant her provisional liberty post-conviction. Third question. Should the Nelson Mandela rules provide sufficient basis to grant bail in the case of Bini Janet? The answer is no. The Nelson Mandela rules, which is based on the United Nations Standard Minimum Rules on Treatment of Prisoners, is not applicable in this case because it does not support the release of PDLs pending the appeal of their conviction of a capital offense. Thus, Bini Janet failed to allege, much less prove, any source of right under the international or domestic laws to warrant her temporary release. Take note, the Nelson Mandela rule states that PDLs who require specialized treatment or surgery should be transferred to specialized institutions or to civil hospitals. Number 2, every prison should have a healthcare service tasked with evaluating and improving the physical and mental health of PDLs. And last, PDLs who are suspected of having contagious diseases are clinically isolated and given adequate treatment during the infectious period based on the case of People of the Philippines versus Revilla 2021 case.